Good afternoon and welcome everybody, and thank you to this our very first hybrid webinar. We're pleased to have so many of you here, far more than we expected. It's unfortunate we can't all be together in the same room, but at least this is halfway there. I am Vanya Karth. I'm the director of the Democratic Governance and Rights Unit, where we focus on research and advocacy around judicial governance. The issue of online courts has been concerning us since the start of lockdown, and we've been conducting some research in this regard. And we thought it was a timely moment to have a conversation about what online courts have meant for access to justice. At the same time, we also developed a short video on how to do online courts. We realized quite early on in the day that it wasn't as easy for many people to get it right. And with the very generous funding of the Hans Seidel Foundation, we've made a very short video which explains how to do it so that there are no people who think there are cats in the room, and that people's faces can actually be seen. We will show you a short little launch at the end of our conversation. So with that, I'm going to hand over to my colleague Mbekazeli Benjamin, who is going to be our moderator today. Thanks, Mbex, over to you.
Thanks, Vanya. My name is Mbekazeli Benjamin, and I'm at the Democratic Governance and Rights Unit. I'm a researcher there. I'm not sure that I should take off my mask. Is that COVID compliant?
My close.
Oh, okay. Thank you.
They're saying it's quite soft.
Is it too soft? Okay. Sorry for that. Yeah. And thank you very much for all of you for attending, those attending in person and those attending online. We appreciate the interest. Vanya tells me there are about 300 people who RSVP'd, which is, it tells me two things. Number one, people wanted something interesting to do on a Wednesday afternoon, but the most important thing it tells us is that this conversation is timely. A lot of us in this room are interested in what access to justice looks like under the pandemic, because obviously the pandemic has affected almost every aspect of our daily lives, and it's only natural that we'd also be concerned about what justice looks like under COVID-19. And so we've decided to put together a panel of judicial officers and a practicing lawyer who will share with us their experiences of providing access to justice under the pandemic and using online courts to do that. They'll share with it from the different perspectives in which they come from, and we'll just have a conversation. The idea of today's event is to have a conversation. We'll obviously not be able to cover all the issues, but we're hoping that it will at least give us some food for thought. It will spark some ideas about how do we ensure that access to justice is ultimately achieved, even despite the restrictions and the difficulties that we are under COVID-19. So I have four panelists who will all share with us their thoughts. But before I go into the panelists, I just wanted to quickly give some housekeeping rules. Because this is a hybrid event where we are both in person, so there are rules that apply there, and also online, there are rules that apply there. This is going to just take a minute to run through. So for those online, all participants, unfortunately, will not be able to switch on their videos or unmute their mics. But we do encourage you to share questions on the chat function, and we'll be able to take them and respond to them as we go along. And for those in the room, you can raise your hand, and the camera will be able to pick you up, and for those online will be able to follow your question. So that's the main thing. And then we'll, at the end of the event, for those online, there will be a poll. If you can, just quickly run through the questions in the poll, that will really be helpful for us. And I'll just quickly start us off with just the introductions of our panelists. On our panel, we have Judge Roland Sutherland, and we'll have also Judge Glenn Goosen, and then Regional Court President Jackie Wessels, and Advocate Tererai Mafokitswe. So just a quick introduction. We'll start with Judge Sutherland, and then we'll move on to the other speakers, and then later we'll have a Q&A, a discussion between those of us who are listening to them and our four panelists. So to kick us off will be Judge Sutherland. And Judge Sutherland, just to introduce you, Judge Sutherland is currently the acting Deputy Judge President of the Johannesburg High Court. So it's called the Gauteng Division, Johannesburg. So he's responsible for that, and he's been a judge at that court since 2012. He's also had an acting stint in the Supreme Court of Appeal. And before he became a judge, he practiced for many, many years as an advocate at the Johannesburg Bar. He was a member of the Johannesburg Council, eventually being chairperson of the Johannesburg Bar Council, and also a leader of the Bridge Group of Advocates in Johannesburg. Judge Sutherland, welcome. If you could switch on your video, Judge. And then I just have a question that will spark or that will start us off. So, Judge, if you could explain in about 3 minutes or less, how did you, in the High Court in Johannesburg, what is commonly known as a very busy court, one of the busiest courts in the country, how were you able to still continue to get the court running during the lockdown? When the lockdown started and as the lockdown gradually was relaxed, and also just give us a sense, to paint a picture for us of how things are looking at the Johannesburg High Court.
Right, thank you very much. I'm not sure if I can be heard.
We can hear you.
Am I being heard?
Yes, we can hear you, but we can't see you. Please switch on your video.
Yes, I've tried to turn my video on, but it tells me the host has stopped it.
Hold on.
Okay, our host is not helping us. So yeah, I think.
The host has probably seen me before and decided it's better not to see.
Oh, he's saying that the host is sabotaging you. let's try and get you on the picture. And we'll just.
But it's not letting me get video.
So while we're waiting for Judge Sutherland to come onto our screens, we'll also have Judge Hosen, President Wessels, and Advocate Mafokitwe will also come on. Judge Sutherland, we can see you now.
There we are. All right. Okay. Thanks very much.
Thank you. You can go ahead.
Well, thank you very much for inviting me, and thanks to everyone for taking the trouble to take an interest in this very important topic. As you've heard, I need to put you in the picture about how Gauteng has managed during the COVID. And in short, we've had an extraordinarily positive experience. That isn't because we're exceptionally clever, except in as much as we were clever enough before the COVID arrived to introduce the Caselines digital documentation system. And that really is the key to explaining how Gauteng has had a positive experience. As you may know, or perhaps some of you are not familiar with Caselines, the idea in essence is that you have a paper-free environment, and everything that the judge needs to know from the court file is in digital form and available online. Now, this, of course, was critical once you disperse the judicial officers and their staff and the registry staff to various other places, and everyone has to work through a remote system. Luckily, certainly in Pretoria and Johannesburg, we've got the benefit of having extraordinarily good modern urban fiber connections. And so very many of us have operated on fiber. Those who have not have had to use their mobile data, and that in some cases has been problematic, but by and large, connectivity has not been a serious problem. Also, happily for us, the profession in Johannesburg and Pretoria were already familiar with a lot of digital aspects. And certainly as far as case lines are concerned, they came on board enthusiastically and embraced the system, so that it was quite possible, to give you a concrete example, for a judge to sit in his home, as I have done, my secretary to sit in her home 20 kilometers away, the court staff to be at another place some 20, 25 kilometers away, and communicate absolutely reliably with one another in regard to everything that needs to be done. The one exception to our positive experience was in respect of criminal trials, which, as you will imagine, has its own particular problems. And naturally, the prison authorities were reluctant to allow people to come to court to run physical trials because of the fear of infection. And for quite some time, it was the position that we could run no trials at all, but that was quickly repaired, and we have managed to arrange trials where in some cases they are fully physical with social distancing rules in place, or in some instances the judge sitting in his chambers and communicating with counsel and the accused and the prosecutor in court. And so there is virtually no backlog whatsoever in either of the two Gauteng courts as a result of COVID. There are, of course, certain compromises which had to be made, and that was we had to make sure that those who attended the hearings wouldn't firebomb us. And that, of course, has inhibited to some extent the transparency and the public openness of the hearings. But that has been overcome by the fact that our rolls are published on websites of the local attorneys and of the bar. And so journalists in particular are able to determine exactly where and before whom a particular matter in which they have an interest is taking place. And by simply contacting the secretary of the judge in question, would have got access to the hearing for the asking without any real formalities at all. The local profession has also come to the party in unexpected ways by creating what are called witness rooms. So there would be a cubicle in which there would be a camera linked to the online connection, and there would also be other cameras which could determine whether or not anyone else was in the room. And so the integrity of oral evidence given under those circumstances was secured. Once again, that's the benefit of being in a metropolitan area. In regard to the question of issuing orders in this situation, several ideas came to the fore, but by and large, what one has done is had orders either emailed in Word format to the judge for that to be edited and then signed and then uploaded to case lines, or to have the draft orders on case lines where the judge or the judge's secretary can download that and make the annotations and adaptations that are necessary. As far as the question of record keeping is concerned, all the proceedings have been recorded and they are transferred the following day on an audio disc to a given destination, which is run by the chief registrar. So all in all, we have felt very positive about remote hearings for that reason. And to emphasize, the chief reason for our happiness and our good fortune is the ability to use case lines. Are we going to keep any of these things even when things do return to whatever we call normal? We certainly have an appetite for that. One of the most immediate things that comes to mind is how to deal with urgent applications after hours. And there's always been issues of safety in regard to court staff and the judges traveling at night and so forth. But if you have a matter after hours or over the weekend, that can now be dealt entirely remotely, and that may well become a permanent feature. Similarly, the local profession has taken to holding pre-trial conferences by video link, And no doubt many consultations will take place in that format as well. In large, this is in keeping with what we are aware is taking place overseas. And we intend to expand our capacity to conduct work in this way. One of the things we foresee is rather like this very hybrid meeting we're having now. Court cases in the future may well be hybrid in the sense that the judge will be in court, counsel will be in court, or perhaps not all of them. If one counsel is in Johannesburg and another in Cape Town, it may spare the trip, and one can simply have that counsel participate through a video link. And more especially, if, for example, one takes medical negligence cases, if you want an ophthalmologist or an enterologist from Cape Town to give evidence in Johannesburg, instead of that person coming up and spending 2 or 3 days on standby, that evidence can be led through a video link as well. So largely, we are happy with what we've achieved, and we're looking forward to seeing how we can improve that, and to see what other divisions are doing with the resources that have been available to them.
Thank you very much, Judge, for painting us that picture of the court situation in Johannesburg. It seems that you had the benefit of good infrastructure, and so you were able to quickly adapt to the court online system and be at the stage that you are, where you are currently having no backlogs. So what we, based on what you've just said now, I think we'll just take a quick tour to other parts of the country. And I think we can go to Limpopo, where Regional Court President Wessels is, and she can paint a picture for us of how the situation was in Limpopo. And Ms. Wessels, I want you to sort of touch on some of the notes that Judge Wessels spoke about in terms of the infrastructure, in terms of connectivity, and how the actual cases were run. As I understand it, there were some cases that did not run during the hard lockdown, for example, for good reason, and in terms of the regulations that were issued by the minister. Certain cases were prioritized, and I'm thinking of domestic violence cases, maintenance cases. Some of those cases were prioritized, whereas others were not prioritized. So if you could just paint a picture for us of how things looked in the courts in your region. And before you do so, let me just quickly also introduce you for people who don't know. I think you don't need an introduction, but I'll just go through the trouble. Regional Court President Wessels is the Regional Court President of Limpopo. She started off her legal career as a prosecutor, which is why she's so clued up on the courts. But she started off as a prosecutor, and then later she taught law at UNISA and at Justice College. And then at some point, she was also a district magistrate's court. So she's quite familiar with the district magistrate's court. And then she's now at the regional court. And Magistrate Wessels, I do want you to just speak to us about the regional court. And if you may, I'm taking advantage of your knowledge now. Also speak about the district courts that you are familiar. How did you manage to provide access to justice during the lockdown and even presently?
Thank you very much, and good afternoon to everybody. Yes, in the days just before the lockdown, the hard lockdown started, we were actually having a PEC meeting. So that gave us all an opportunity, in particular for us in the lower courts, to have the conversation with all of the other role players, and actually came up with a basic plan to deal how we're dealing with courts during the hard lockdown. As
sorry to interject, but what is a PEC for some of us?
Our Provincial Efficiency Enhancement Committee meeting that is led by the JP, where myself and the Chief Magistrate and the JP and all of the other relevant role players were, as well as the sub-cluster heads, So like I said, that made it easy for us to actually, as a province, come up with a plan, in particular for the lower courts, for the hard lockdown. Now, we, for example, don't really have a lot of AVR connections with the prisons. However, I must tell you that WhatsApp video call was everybody's savior in the beginning, because we were able to make arrangements with the officials at the prison to do the postponements with the prisoners and the awaiting trial detainees via WhatsApp video call. So in the regional court, we were in a position that for the first original 3 weeks of the hard lockdown, we could actually make arrangements before the lockdown start for most of our cases. And the district court essentially needed to go in because of the fact that they were not really able to do that. After that, during April last year, we were able to get Teams licenses. And then we did a lot of hard work about training ourselves and each other in utilizing Teams. So we were able to start, in particular for civil, to do a lot of the matters, in particular the divorces, virtually. We took a lot of trouble to also kind of do webinars about how to do it and what to do, not just for ourselves, but also for stakeholders. And that assisted a lot, you know, and even if necessary, having test meetings with practitioners, so that we all get familiar about how to use it. We did not have case lines. We, however, in Limpopo, already had central email addresses for all of the regional court civil seats that we had been using since 2019. So that actually facilitated filing of matters because people were able to email everything, though we did also have the boxes outside the courts for people to do the filing there. And obviously in our courts, we had to do the taping of areas so that everybody know 2 meters distancing and for social distancing purposes. And once we started going back to court from around May, regular meetings on a local level really made a difference to be able to prioritize and to see how we're able to proceed further. And that is also where, for purposes of the criminal matters, we started using virtual appearances for witnesses because of the fact that witnesses could not travel across provinces and districts, etc. So that actually assisted to get some testimony happening as well. From around September, we actually in the regional court had 2 different projects going for purposes of trying to deal with the backlogs. The one was 100 days divorce backlog project, where we also were able to get the mediators involved who were willing to do it for free, including virtual mediations to help and assist parties to settle matters and for us to be able to do and finalize divorce matters. And we was actually very successful in this endeavor. It really made a difference in catching up with the matters that could not have been dealt with, particularly during hard lockdown. And for the criminal matters, we had a 100-day gender-based violence and femicide priority role where all the stakeholders got involved in order for us to prioritize those matters in particular and to get them finalized. Obviously, there were the issues about court closures, parties being in quarantine or ill, and making it a bit difficult to always predict what exactly the week will bring up. Though up to December in Limpopo, our infection rate were quite a lot lower than most other. So I suppose we were spared some of the problems that other provinces had. And one of the issues we had was we basically had to be in court for the recordings of any of the virtual proceedings and testimony that we did, because we're using our own the data, mobile data that we had, because we can't use the DOJ lines because the bandwidth is not enough. And obviously in some areas, we do have not very good reception, unfortunately. But it is also a question of making sure that you've got the data for the network that has got the best reception in the area. We all upgraded our data packages to ensure that we have enough data to enable us to work virtually, even inside a courtroom. Like I said, because we had to ensure that the matters get recorded on the CRT machines, and there was no other way to do that because the staff did not have data and access to computers all the time. We did have some issues with some of the judicial officers having old laptops that did not have cameras and speakers and things like that. So that made it difficult for those judicial officers to really be able to do virtual. But most of them are getting new laptops now. So hopefully that will enable them in future to be also more productive in this. With regard to the domestic violence in particular, there was also 100-day projects there that we had. 2 of our district courts were part of a national project, and then there were additional courts that as a province we had looked at that had the highest numbers to assist them to also work down their backlogs, which has also been actually quite successful. And they are also currently repeating that project, and it extended it to 6 more courts. So in total, that would be currently run at 14 of the district courts in Limpopo. And we in the regional court had started in February with another 120 days divorce backlog project that will be up until the end of May. Even though we were in the second wave, we were able to do that because of the fact that parties can email everything and we can do it virtually. So that really made a difference, like I said, in particular for the civil matters. We didn't just do divorces online, I must say, also applications and other matters we were able to do virtually. I must say, WhatsApp video call generally for postponements or when parties are not there, practitioners or prosecutors, etc., that really made a difference in being able to quickly connect with somebody for purposes of postponements, both in civil and in criminal. And and I just wanted to add, currently we're also doing a priority role project for the criminal matters, again, to deal with the backlog. Good working relationships with everybody and regular, this like planning meetings, they do it either weekly or every second week. That really made a difference in order to be able to work better together and to make the necessary plans and arrangements, in particular for witnesses' testimony as well.
Yeah. And thank you for that. You've preempted some of my questions, but we'll come back to some of the issues you raised. It's quite interesting how you described that you were actually running virtual courts, but in physical court buildings. That's an interesting sort of contrast to what Judge Sutherland was speaking about earlier. And it's something that perhaps you can explore with Judge Goosen, because Judge Goosen, you're based in the Eastern Cape, and the Eastern Cape we can compare it to Limpopo in terms of there are urban centers, but they are quite rural areas where the connectivity might not be as strong as one would expect in the urban centers. There isn't a fiber network, the one that Judge Sutherland described earlier. But at the same time, you in the Eastern Cape, Judge Khosendu, you were able to get ahead of everyone, if I can say. You're the only court, except for the Constitutional Court, that has a YouTube page. So tell us about that. How did you guys adjust to conducting court online and still provide access to justice? Judge Hossein, are you on?
Yes, thank you.
Thank you. Before you speak, I should actually also introduce you because I think we've started the tradition, so you must now continue. So Judge Hossein has been a judge in the Eastern Cape since 2012. Before that, he was also a member of the bar for a number of years. And I think he's still acting at the Supreme Court of Appeal, if I'm not mistaken. And you've done so for a lot of last year. But we are particularly interested in how you and other judges in the region were able to adjust to working in this new world that we're living under. So if you could paint us a picture of how things looked in the Eastern Cape.
Yes, thank you. And thank you very much for inviting me along. It's a privilege to be here. So we didn't have the benefit of case lines or any, certainly not in the High Court, having sort of digital platforms already in place. So our approach had to be different. What we felt was very important was that we should, as far as possible, enable the High Court, and I can only speak on behalf of from a perspective of the High Court. Different circumstances apply in the lower courts, but the approach was to ensure that the High Court could function to deal with applications, all applications, whether unopposed or opposed applications, and certainly all urgent matters. And really the target initially in that the stage of sort of hard lockdown, level 5, was to work out how it is that, and what we would need to do to enable the 5 court centers, because as you correctly point out, the Eastern Cape is a very challenging province, just from a logistical point of view, not only largely rural, but the High Court itself operates in 5 different centers. So we have in Port Elizabeth, now Gqeberha, in Makhanda, in East London, Mthatha, and in Bisho. So, and of course, in each of those courts, we sit as an application court or a motion court. We do criminal trials, and we do civil trials and hear appeals. So really the first priority was how do we ensure that applications, the motion court, can function? And so the approach was to say we would immediately take it onto an online platform. We would use Zoom. Later, we started using Microsoft Teams. And it was that we would really combine the physical records that we would normally have to deal with motion court with an online process. And so the judge who would be allocated that duty would either go to court and sit in chambers have access to all of the files, or those files would be brought to the judge's home for the pre-hearing preparation. And so we would sit using a Zoom platform with the physical files, because we didn't have a digital platform, and deal with the matter as if we were in court. And so very quickly, practitioners were able to respond to that, and they did. They responded very positively. So we had those hearings in sort of level 4 through level 3 until level 3, which I think was in about May, perhaps a little later. We could run no criminal trials, and the criminal trials were in the High Court were postponed in each of the courts, and we weren't able to run civil trials. Once the lockdown level had eased, we introduced a hybrid system for the running of civil trials. The difficulty we faced with criminal trials, and I think Judge Sutherland pointed out, it's a very it's a major challenge. From the High Court point of view, they're already down. The indictments are served. They're there for trial. There are not a great number of remands, if you like, and so the matters are ready to run. And witnesses are from all over the place. And so it was particularly difficult to organize that on a remote basis. We were able, however, once the lockdown restrictions had eased, to adapt several of the courts, putting up appropriate screening, demarcating areas, demarcating witness areas, and so on, to conduct physical hearings for criminal trials. And we dealt with the backlog that had developed by prioritizing those in each of the different centers to ensure that those that had been part heard matters, for example, we brought on to try and complete those, and then prioritize the new matters, identifying short-running trials, those which would not involve either a large number of accused or a large number of witnesses, so that we could at least get those through the system as quickly as possible. And that's continued to operate. We have had fits and starts because of health scares along the way, but by and large that has functioned quite well. The fact that we maintained the operation of the motion court meant really that we developed no challenging backlog in the dealing with those matters. We also, as far as civil trials are concerned, what we did in all of the courts is we took our case management system and the protocol that applies, we took that on into a virtual setting, so that all of the case management hearings, pre-trial processes, all of that we did via either Zoom or Microsoft Teams. But the other thing that we did within that was to, I suppose within the spirit of Rule 37A, judges encouraged the parties to narrow the issues very significantly, and encouraged either resort to mediation or attempts to resolve the dispute. And interestingly, I think our settlement rate actually increased over that period. And that has caused, I think, some reduction in the backlog. I think we can talk about there's other logistical problems which are non-COVID related, for example, with the road accident fund matters, but those are really particular challenges with the running of a trial roll. To pick up on a few things that Judge Sutherland indicated. Record keeping, again, our approach, whether it was on Zoom or using Microsoft Teams, we could record those sessions and did. The practice directive itself deals with that issue, and that's then provided to the registrar for central record keeping. So there was no particular difficulty with that. Because of the fact that we were using the hybrid system, both physical files and online, there's really no difficulty with the issuing of orders. Those could be issued and then they would be filed, as it were, in the court record. There were obvious compromises, I think, and I'll end here. The big challenge, of course, right from the outset was, how do you conduct an open court if everything's remote and you only have the participants or their legal representatives that are part of the platform? And we were concerned from the beginning with that. And it is that which resulted in us setting up a little YouTube channel so that at the very least we would be able to record, and we did. We recorded sessions of the motion court and then made them available immediately thereafter, so that at least there was some transparency in the conduct of those proceedings. And of course, what we did as well was, when we set up each of those Zoom hearings or the Microsoft Teams hearings through the registrar's office, we invited the court reporters to participate, and in many instances they did. So they were able to report on court proceedings. But it remains a challenge.
You took.
Thank you.
Thank you. I was going to ask whether was this an own initiative? Was this something that you in that division took into account and preempted? And I want to actually push that question a little bit further to ask about unrepresented litigants. How were they accommodated in this new virtual system? I'm thinking about litigants who don't have a laptop, who don't have a mobile phone that could be able to tune in to a virtual court. How were those cases dealt with? And it's a question for you, Judge Khosenbi, but I'm only picking on you, but we can ask anyone else.
Good. All right. The first part of the question is it was our own initiative. Right from the sort of late March, the Judge President and a few of us were involved in discussions about how we could do this, what we needed to put in place, and the decision was taken is that we would try to keep things as open and transparent as we possibly could, that we would use Zoom as a way of doing so, and set up a YouTube channel in order to facilitate at least publication of those processes. Recognizing, of course, that it was an imperfect solution. I think the subsequent practice directive makes for more regulated provision for that as a practice, and it's something that I imagine that we'll be developing in the months to come. As far as the second aspect, a very important point, the primary focus, as I said, was on motion court. And of course, our experience in motion court in each of the centers, and I'm sure this applies in many other divisions, is that we very often have litigants arriving at court on the day to deal with a particular matter, and they arrive in person without legal representation. And this is true particularly, say, in foreclosure matters or instances where there is a sale in execution of a property. And so the approach was, we will be operating online, but the judge will either sit in his or her chambers and conduct the matters online, or, and I did this on several occasions, sit in the courtroom itself. So I would literally be in the court with no one else around, with the laptop and perhaps my clerk, and conduct the court from that venue. And we decided to do that because even though there were travel restrictions, it was possible that persons would arrive at court, and we had this on several occasions. And then what would happen is the court staff would bring that individual into the court itself, and they'd be in a position to ascertain what would need to happen. And invariably those matters were then postponed so that arrangements could be made for that individual to be given access to either court documents or to technology to be able to deal with a subsequent virtual hearing. So that's how we did it. A very sort of fly by the seat of one's pants type of approach, quite practical.
Okay. Thank you, Judge Wessels. Sorry, Judge Goosen. We will now shift. We've been hearing from judicial officers. Now we want to hear from a legal practitioner, and that's Advocate Mafokizwe. You were at the receiving end of all these wonderful things that the judicial officers are speaking about. And so I would like you to put us in the picture of a legal practitioner who's having to now do virtual court, and how did you keep your practice running? How did you continue to ensure that your clients receive justice even under this period? And I specifically want you to address a question that just came in about the overheads that come in with this new infrastructure, having to buy a laptop, sometimes having now to spend a little bit more money on data and that kind of thing. Could you just give us a picture of how did lawyers survive? At some point, you actually were under lockdown. You couldn't even move around. So also tell us about those troubles in just 3 minutes of this.
Thank you very much. You recall that when the lockdown started, we all thought it was going to be 6 weeks and it goes away. It was only a bit later that we started realizing that this could be a new normal for a while. The first challenge was really to access courts, because courts had to close down except for the agent court. That kind of work we could do, but where you had matters set down, you couldn't run your trial. So that immediately put a stop to part of our practice. Those who were doing advisory work basically could provide advice because you could work virtually from home. The access to the court was really the biggest problem. And we thought after 6 weeks, we would be able to access courts fully. It did not happen as quickly as it did. We also faced the difficulty that we were not classified as an essential service in the beginning. Then when we were, we required permits. And for advocates, one of the funny things that happened is that we were required to get permits from employers, but we are self-employed. So in the end, one had to write himself or herself a permit that allowed them to go to chambers and leave home to go and collect, say, briefs and the like. But definitely in the beginning it was difficult, but we all thought it was a short-term thing, and the courts were quite quick to adjust by providing for virtual hearings. You mentioned the issue of the additional overheads. I don't think it is for most practitioners, it was a major shift because most of them already had access to laptops, many already had access to the internet. Where you didn't have this infrastructure, say at home, that's where you probably needed now to make sure that you have this access. There's concern worldwide about internet exclusion, which remains an issue that how does somebody who is out there in remote areas where you don't have enough coverage then bridge this gap if there are no longer physical hearings taking place? But definitely, my experience is that most practitioners could, of course, for the smaller firms, smaller budgets, it was not an easy adjustment. Some of the law firms already had facilities that they would use for consultation with international clientele. So for them, it wasn't as difficult to adjust. Clients also, many clients could consult with either their counsel or their attorneys through video calls. So that made a bit of the work easier. If I may turn to the reaction by colleagues and witnesses and clients and judges. The judges have been very good. I mean, barring a few hiccups, the judges adjusted quite quickly. Some of the difficulties we have seen relate to uneven access to the internet. When I say uneven, I just mean the quality of the connectivity. So in some of the hearings, you find that your opponent doesn't have as good a connection as you have. And then you may have to take breaks for them to find a better spot or to change equipment. Those have been quite frustrating delays. In trials, we have found that, say, expert witnesses welcome virtual court hearings because they don't have to travel from anywhere. So if you have an expert from overseas, it's much more convenient for them to sit wherever they are and testify. Judges have also been quite accommodative. I'm aware that a few of my colleagues have actually had hearings held outside South Gauteng online with a judge sitting in a boardroom somewhere. Some have even gone to the extent of even having a hearing at a hired venue, and it became quite easier for the judge also to access that place. As you know, going to a court like South Gauteng is a bit of a mission sometimes because of it's a crowded area, and a lot of practitioners have actually enjoyed the fact that they can access court argumenters, do trials, running these trials from their own offices, which is a bit more comfortable with a bit more resources. And this has been quite welcomed by many. If you turn to matters that I think will continue to be, what will continue going forward, I think we have tested the advantages of virtual sittings. There have been some challenges that we have managed to work through. Case lines for Gauteng has been a great benefit to the extent that when you are involved in a matter in, say, in another province that doesn't have case lines, you actually see the difference, and we hope that this facility is going to spread to other provinces. Going forward, there's probably going to be a change in terms of physical experience in certain matters. Quick to mind matters like unopposed applications, they may, for the foreseeable future, actually become entirely virtual. The problem that you face if you make that permanent is that some of the hearings in unopposed matters concern evictions. And a lot of these cause a problem, particularly say in South Gauteng, because often judges would like you to consult with the people being evicted, to speak to them, and they don't have this facility. Some have been able to connect to hearings in which they have interests, but connecting from some of the dilapidated buildings that they are seeking to evict them from, and some of the background in those in those hearings are not very good for the dignity of the court. But appeals are likely to also be heard virtually. We have seen courts worldwide, the UK Supreme Court, we've seen even the US Supreme Court. We have seen the ConCourt has been running virtually, the SCA. So I suspect that in future there may be an election by the parties whether they want to be physically in court or to be heard virtually. Leave to appeal applications are also some of the applications that I think may in future be heard virtually. Case management meetings. So we see now that there are actually many advantages to virtual hearings, and we need to make sure that we have the facilities to make sure that we do not have disruptions and that everyone can have access to them. Those are my observations.
Thank you so much, Advocate Mafokeng. I was excited to actually hear from your perspective that I actually completely forgot to introduce you, and I broke the actual tradition that I set. So I'm not sure if I can still introduce you, but I'm sure everyone picked up that you are a practicing advocate in Johannesburg, and you were front and center during this period. So the wonderful thing about having hybrid systems like we are currently having, the judges have spoken about it, that they had hybrid systems, but here in particular, we have the Deputy Minister of Justice present in the room, and we have Judge President Mlambo on the chat line. And I'll turn to the answer that Judge Mlambo just posted on the chat, where he said, for underrepresented litigants, there was a special room that was set aside in Gauteng, and there were court staff mandated to assist litigants with access to case lines. And they could, so through that, they were able to participate in the virtual hearings. And on occasion, practitioners who also didn't have IT infrastructure or Wi-Fi, they could also use that facility. So that's something from the chat line. And if you have more questions for those online, please post some of those on the chat line. Now, I could spend the whole time speaking because I'm really interested in this topic, as you could imagine, but I would like to give the people in the room an opportunity to ask. For those on the chat line, please continue to post the questions on the virtual system. So I'll just take one round of hands, and if there aren't any, I have plenty that I would ask myself. I see two hands, Prof. de Villiers, and so you'll follow. One more hand, and then we'll close this round. Okay. Oh, there's a third one. Okay. So you can go ahead, Prof.
Thank you, Chair. My name is David de Villiers from the Faculty of Law, UJ.
I think you need to use the mic so that people online can hear.
Thank you. I'm David de Villiers from the Faculty of Law at UJ Johannesburg. Thank you, Chair, for the opportunity. Not working.
Oh, sorry. It seems the mic is not working. Just get you a new one quickly.
Thank you. Not going to
we can hear you
myself a third time. Thank you, Chair. My question actually refers to, the old saying, if two advocates agree, one is not thinking. If all parties agree to a virtual court, it's fine. If parties agree to a hybrid court, it's fine. The question arises where there's a dispute. One party will say, this infringes my right to confrontation, in other words, cross-examine in the old-fashioned way. And the other party will say, but I also have a right to a fair trial, and that means I want to face my witnesses in person. My question relates to whose decision is it going to be? Some jurisdictions say it's a discretion by the court that can say we're going to follow the following route. My concern, and it's a real concern, is we need in South Africa to have clarity amongst different provinces. We can't afford to have in one jurisdiction one set of rules and in another set of rules. My question is, whose decision is it? Is it a majority vote? Must all parties agree? Is it the discretion of the court to decide? Are we going to follow a certain process? That's the first part of my question. But the second that goes with it is the very important thing of Industry 4.0 and new technology. One thing that COVID-19 did, Chair, was the wheels of justice turned slowly, but it's been pushed to move quite fast last year. My question is about new technology, about artificial intelligence, about the use of robots to assist, and that is a new line of questions. But isn't it now time for the people that were quite skeptical about change now to see that change is now forced upon us and we must move forward because we are forced to do that? Thank you, Chair.
I hope those questions are not addressed to me.
Anyone?
Okay, so we'll just take 3 questions and then we'll answer them. I'll take the liberty of picking who answers so that we can use our time efficiently. But you can go ahead, sir.
Thank you, Chair. My name is Tembi Sonoselela. I'm a member of the National Bar Council of South Africa. The question that I have is that in as much as it is very nice to have online courts, but is there any measures in place to ensure that we don't experience cyber attacks, as we have seen on other organs of state that have experienced such issues with online and virtual sittings? The other question that I have is with regards to the enforcement of professional legal ethics in virtual sittings and proceedings. Are the presiding officers able to control the proceedings, and are the presiding officers able to manage such proceedings? The last question that I have is...
that will be your last.
Yes, definitely my last question. The last question that I have is that we all understand that even the presiding officers, they are human beings. What happens now in a situation whereby in a specific division, there is a particular judicial officer or quite a number of judicial officers who are infected with COVID-19 and cannot sit and even have virtual sittings? And then doesn't that affect the judicial capacity of that jurisdiction? Thank you.
All right, the last questions and the last question, and then we'll move on.
Thank you, Jean Redpath from the University of the Western Cape. I'd just like some more information on this case lines. Is it a proprietary software? Is it developed by people within the court itself? Where does it come from?
Thank you. So in terms of the responses, I will ask Judge Sutherland, you take the question on who owns case line. Is it a proprietary system? Is it a free system? And the question of cyber attacks, how do you deal with those? Have you experienced any? And then there was a question of, do you think that we're ready to move in terms of having robots decide cases instead of judges, if I'm not bastardizing your question? And then I'll ask President Wessels, you can please take the question of who enforces legal ethics, if you can deal with that. And then there was a question about in terms of how do you sort of make sure that the costs of virtual hearing, I'm reading from the online questions, but the costs of virtual hearings, how do you manage those costs, if I understand the question correctly? And then there were 2 more questions that I'll ask Judge Hossein to deal with. But for now, can you, Judge Sutherland, deal with the first 2 questions, and then Magistrate Wessels, please follow after.
Certainly, thank you for that. CaseLines is a proprietary software program. It's owned by a British company. The OCJ have contracted a license with them to use it, at present only in the Gauteng province. although it has been offered around the country, but progress in that direction is a separate question. The use of case lines at present in South Africa is a pragmatic one because we're using it beyond its prescribed scope. It should normally be used in conjunction with what is known as an e-filing system, which enables a litigation attorney from within its office to prepare, upload, and categorize documentation, file it in court, and so forth. At present, it's hoped that that will roll out later this year, perhaps as early as July. And case lines, which is primarily an evidence recording and hearing portfolio device, will then shrink in its use. At the moment, it's being used for both purposes. And what took place logistically is a crew of technicians came into South Africa for the rollout and were with us for several months and trained a South African crew to take over to maintain and sustain the particular operations of it. As you'll imagine, because of the very many people who have to use it and use it in different ways, there were a lot of calls for training and many inquiries about how it was to be used or not to be used and so forth. So that's ongoing. And we should see further quite exciting developments in place before the end of the year. The issue about how safe it is was a controversy at the beginning. Zoom in particular came in for a lot of controversy on that score. They've since improved their security protocols quite considerably. And to the best of my knowledge, Teams was not visited with the same criticism. Our experience in Gauteng is that we've had no cyber attacks as such. On occasion, it may be that a judge has looked at the participants list and clarified who's entitled to be there. But largely that's been in regard to preserving bandwidth. One of the great shortcomings of video link hearings is that the connectivity doesn't always sustain a large number of participants. And as we are doing here, we are assisting bandwidth capacity by remaining off screen and muted. And so far as there's a prospect of IT, or artificial intelligence rather, coming into being, that's a debate that's taking place at the present moment internationally. And in various jurisdictions, there are serious contemplations of using some kind of machine technology in order to process legal disputes. I must confess, quite frankly, I'm quite skeptical about that being anything feasible. We're not quite ready to replace judges with machines. It doesn't quite work that way, despite views to the contrary. But one has been so wrong about all kinds of other technological devices. It may well be that I can live long enough to see a machine displace my successors in office. And so that's the position that we're in now. One of the things that may be a good idea for divisions who don't have case lines is to lobby for its utilization, so that the point that Professor de Villiers, I think it was making, is that there isn't disparity amongst the various divisions. Uniformity in regard to technology across the country ought to be something that we should take for granted. And of course, there is a money problem, but these things need to be solved over time.
And President Wessels, you are up next. There was a question on who enforces legal ethics in virtual hearings, but I also want to add a question that just arose from what you said. You said that you use your own data, you have to top up data during court hearings or the WhatsApp video hearings. The question is, whose data are you using? Is it yours? Does it come from your pocket, or does it come from the Department of Justice? Can you also just take that question as well?
Thank you. To start off with the data issue, as judicial officers, we do get a data allowance. And luckily, with the data prices going down dramatically in the beginning of last year, most of us had data packages, you know, where we get allowances for in any event, and we were able to just upgrade it to get more data, and often for the same or even less money. So we get both data allowances as well as phone allowances. So that is why using WhatsApp video calls is also, we're able to do that because of the fact that we do get these allowances. And obviously we're using it for official purposes, and this is official purposes. I want to just quickly mention something that with reference to case lines. The high courts are managed by the Office of the Chief Justice, and the lower courts by the Department of Justice. So we do not have case lines. However, the Department of Justice actually already before COVID started, were busy developing a civil web portal for the lower courts. And for various reasons, we were actually supposed to test it previously before COVID, and then we couldn't. But we're actually, it's very exciting. We're actually at the stage now where the first piloting of the civil web portal will actually take place before the end of the month in Polokwane, and thereafter it will be rolled out. So the lower courts would be in a different position in the sense that hopefully before the end of the year, it would be rolled out to all of the lower courts to have the civil web portal. They've already also started with the piloting of a maintenance web portal for maintenance applications, and they're busy with the development of web portal for the applications in respect of protection orders, both domestic violence and harassment, which hopefully also in the next year will be rolled out to all the courts. That will really make it so much easier for practitioners. And with the web portals, that is where a practitioner or a party can sit in their office at home and actually upload applications, and in civil matters, the summonses, get it issued electronically, and everything will be electronically available. In the same time, they're also developing a e-judiciary workspace for us. So we will be able to get access to everything, and we will be able to do our court orders electronically. With criminal, for example, the warrants for arrest, the J7s, etc., we'll be able to do all of that electronically. So that really will make a big difference in our ability to be more effective and efficient as well. So those are really exciting developments that is taking place, and that hopefully will also change a lot of the ways that current litigation is being done. As you may know, the e-justice proposed e-justice rules to change the current rules to accommodate e-justice is out for comment, and comments should go to the rules board by the middle of May. And I trust that everybody had been looking at it and will be able to assist us at the rules board to ensure that we have workable and good rules in place that will actually facilitate the process to make it so much easier with the use of technology. But coming back to legal ethics issues, if I can firstly just mention with regard to Professor de Villiers' question about the possible infringements of my right to cross-examine or fair trial if I'm not facing my accuser or the witness in court in person. since, when was it? About 1994, I think the first time we started using the CCTV system in courts. So it's been a long established practice in our courts, in criminal cases in particular, that a witness can testify using a CCTV system. And if you look at Section 158 of the Criminal Procedure Act, it actually is wide enough to accommodate remote virtual testimony as well. Furthermore, it was originally in the Judicial Matters Amendment Bill of 2018, provisions to be included in both the Superior Courts Act as well as the Magistrates Court Act that would allow for the testimony of witnesses using audiovisual links in any proceedings, as well as the utilization of intermediaries in, for example, civil or domestic violence matters. That Judicial Matters Amendment Bill has not been through, but in the meantime, as part of the so-called gender-based violence and femicide amendments, it is now currently in the Criminal and Related Matters Amendment Bill before Parliament. So hopefully we'll get those changes to the law that will make provision for audiovisual testimony of witnesses in any kind of proceedings in future as well. Because currently, obviously, we're doing this in terms of the directions that has been issued by the Minister of Justice for courts that allows us to do that.
President Wessels, I'm going
yes.
to get that question that I gave you before on legal ethics. I'm going to pass it on to Judge Goosen because
thank you.
You've gone ahead and answered the question about whether it is possible to face your accuser, as Prof. de Villiers was saying, and you've just explained now about this system of CCTV testimony, which is something that is actually what your answer is also explained by, I think it's Regional Court President Vuyokazi Nomcembu from the Northwest. She also explains that the new CCTV system has been in place for some time. So Judge Goosen, now the question of who enforces legal ethics falls on you. And there's another question of whose decision is it to go online? You did a survey, you wrote an article last year in the Advocate magazine where you did a survey of the different rules in different jurisdictions. So if you could weave that into your answer, we'll appreciate it. So the two questions for you, the one on legal ethics and whose decision is it to go online?
Yes, thank you. Right, well, I think by enforcing of legal ethics, I think what perhaps would be envisaged is, if I understand it, really who manages the process in an online hearing to ensure that that all of the participants and legal representatives conduct themselves in accordance with their ethical obligations. Well, it's really a very similar question that arises when the courts sit in person. Ultimately, the court is conducted under the auspices and control of the judicial officer. And so the judicial officer is in control of those proceedings and ensures that, and must ensure, that they are conducted in accordance with not only rules of procedure, but as far as is possible in that hearing, that the parties are conducting themselves appropriately and with due regard to their ethical obligations. And obviously, if an issue arises, then it is for that judicial officer in that hearing to deal with the matter. Now, of course, I think what lies behind the question is, well, how do we ensure that, if you're operating remotely, that, people are not up to no good because they can't be seen in the court? I think largely, that would really only come down to questions around perhaps encouraging a witness that you're dealing with remotely. If you're not in court, you can't be seen by every participant in court, to somehow or another undermine the process. Of course, it's very difficult to manage. One doesn't know whether that will happen. I think the starting point is that it's probably more likely than not won't happen, because that's most legal practitioners who practice are entirely honorable and ethical and conduct themselves in accordance with the ethical obligations, and that we know is the case. So really, as far as remote courts are concerned, there's no different obligation on the part of the judicial officer to ensure that that things are done properly. There are procedures that you can put in place, protocols that can define how parties should deal with a remote hearing. And we've seen that in some of the practice directives, for example. You can put in place a set of protocols that allow all of the parties to feel confident about the way in which the process is going to be run. Those should be transparent. They should be written into the rules of practice of that court. Ideally, they should be rules of practice or incorporated into rules of practice which apply right across the board, across divisions, for example. And so it's in the drafting and preparation of those systems and those protocols and those rules that we can deal with this sort of difficulty. It really does relate to the point that President Wessels made a little earlier on in answering the other question, which I think initially I was going to have to answer, but there it is. And that really relates to a legislative process, a rules-based process, so that everyone knows what rules apply and how to conduct themselves, what is expected of them in the conduct of those hearings.
Thank you.
And then the second question that you wanted to ask, I think there was a question about costs, wasn't there? Should I deal with that?
Yes, if you could.
All right. Well,
the question of how does virtual hearings affect the issue of costs, if at all it is affected?
Well, I would think that the general rule would be, I suppose one's looking at what are the additional costs. There are no court fees in the sense that you pay for the courtroom and the time of the judge. So that's not a cost factor. The judge coming online and operating on the basis of an online platform is really ultimately the state's obligation, because the state has to put in place and provide the facilities for courts to which members of the public and litigants can have access, where they can have their disputes properly resolved in accordance with the constitutional provisions. The costs, if in a form of disbursements, additional things, I would think to the extent that they are significant, and I can't imagine that they would be potentially claimable as disbursements and would form part of an appropriate cost order. But I am having some difficulty imagining what those costs could be. The data costs for the attorney and counsel to link in, would those be significant? They don't charge the petrol that they expend in order to get to court. They simply charge a fee for their attendances. So I don't believe that there are negative cost implications. I think as Judge Sutherland pointed out, and I think also the earlier discussion about cost savings by not having witnesses having to travel, expert witnesses, for example, and spend time. They are potentially very significant cost savings that the introduction of online hearings can bring about.
Thanks. And Advocate Mafoketsi, I don't want to end this without giving you an opportunity, so I'll just ask a question directly of you. And earlier on, when you spoke, you did allude to it, but now we've been looking back, and now I want us to look forward. You mentioned earlier about that virtual courts will now be part of the system, but I want you to think a little bit and give us a response on what are the kinds of negatives or disadvantages of this new virtual court system, especially when it relates to access to justice. We've spoken a little bit about unrepresented litigants in terms of, for example, dealing with an unrepresented accused. How do these issues sort of affect access to justice for those kinds of people going forward?
Thank you very much. I think virtual hearings are likely to, for those that are litigating, as Justice Hussein has said, there is a significant saving on costs. But for those that are poor, and you have mentioned accused persons, particularly say in criminal trials, if virtual courts are to be heard, then there ought to be facilities through which they can actually be tried. You may end up with a dual system where those who can set up facilities are able to access the court. Those who can't may have to physically travel to the court. That will bring in inequality issues. There is obviously the issue of equipment. I mentioned the evictees, people who are being evicted, that they should have facilities, and the Judge President has already mentioned that there are court staff that are assisting them. But we are unsure going forward whether we will have proper facilities, because what we have now are measures that have been brought in because of this pandemic, but we will need to have certainly facilities through which those who do not have the equipment, who do not have access to data, are able to still access the courts. We have seen questions that have flown through from journalists asking about links to court hearings, that they also want access to magistrates' court hearings. We'll still need to find solutions on how we can make it possible for those that want to observe court hearings, wherever the court hearing is being held, so that they could access them virtually. There are obviously the security issues that have been raised, because if you open it to everyone, you may then have the interferences that we are talking about. But certainly there is need for greater investment in ensuring that everyone is able to access the courts if we go virtual. The professor who spoke earlier on mentioned the issue of fair trial and who makes the decision. There may be instances in which an issue of consent has to be put forward, that the person has consented to either be tried virtually or to be present in the courtroom, so that at least we mitigate some of the disadvantages. If you are unrepresented, our law requires that the judicial officer must try as much as possible to assist you without obviously losing their impartial position. For example, a magistrate trying an accused person may ask about mitigatory factors which the accused person is not aware could actually sway the judicial officer in passing sentence. So now with virtual hearings, we'll need to do much more. The free legal aid services will need to have facilities again where they can assist, where we have litigants who are unable to represent them, I mean, to get legal representation, and they have the facilities for these litigants to access justice.
Thank you so much. And on that note, I want to end this discussion. As I said earlier, there's plenty of issues that we can speak about, and we can literally spend the whole day. But unfortunately, due to limitations of time, I'd want us to end this conversation here. But we can still continue with it. I encourage everyone to still continue with the discussion. We will try and get this discussion packaged in some way, whether it's a video or some sort of write-up of some of the issues that were raised here. But I want to wrap up on that. There was an issue of how do courts maintain their decorum, how do court proceedings, how are they run? And the DGRU team, and working with the Hans Sieder Foundation, has prepared a video which explains some of the do's and don'ts of online hearings. And we will get a chance to play it if the technology will allow.
Yeah.
Just a short trailer of that video. And then at the back of it, we'll have closing remarks, and then we'll close. So stick around for the video.
All right, the Western Cape High Court is now in session.
As noted by counsel, this trial is being conducted entirely by video conference. Ms. Johnston. I'm not able to see you, Ms. Imco.
Applicant office, exhibit number 1.
No objection.
So that was just the trailer. The full video will be available on the YouTube page, Democratic Governance and Rights Unit. So the DGRU YouTube page is where you'll find the full video. And with that, I'd like to thank you and pass over to Vanya.
Thank you very much, Mbex. If you could all just very quickly for us complete the poll, which is just a little quick satisfaction survey, really. It'll take very quick. For those of us who are in the room, there is drinks and snacks behind.